The video is jarring in its clarity. A suburban Minneapolis street, crisp morning light. A marked IC vehicle, 2 officers. A man, let's call him Samuel, is standing beside a car, his posture defensive, confused. Words are exchanged, inaudible to the lens. There's a reach, perhaps for identification, perhaps something else. A sudden movement, a shouted command lost to the wind. Then the sharp, catastrophic reports. 1, 2, 3. Samuel falls. The officers approach, weapons now lowered, as a crimson stain blooms across the pavement. Sirens wail in the distance, converging. The news headline that afternoon is succinct. ICE officers shoot man during enforcement operation. The public narrative fractures instantly. He was a dangerous felon, some argue. He was unarmed and terrified, others counter. The investigation, we are told, will be thorough. Justice will be served. But here is the uncomfortable, paralyzing truth that narrative misses. The legal issue simmering beneath the headlines that nobody, in fact, is talking about. Into what precise legal void does a bullet fired by a federal immigration officer in a state jurisdiction fall? And who, if anyone, can truly be held accountable? We are not merely debating the split-second decision of a single agent. We are staring into a chasm of intersecting sovereignties, woven from threads of immunity, conflicting policy, and constitutional ambiguity. This is not a story about one shooting. It is an autopsy of a system designed to make certain acts of state power legally impervious to challenge. This article will dissect that silence. We will move beyond the visceral horror of the video and into the cold, intricate machinery of the law. We will explore the doctrine of sovereign immunity, the ancient principle that the king can do no wrong, and its modern, formidable incarnation in the United States. We will chart the tangled jurisdictional map where federal immigration enforcement meets local policing, a landscape where constitutional protections can blur and shift. We will examine the rare, narrow windows for civil litigation, like Bivens' actions and the towering barriers they face. We will scrutinize the internal disciplinary mechanisms within agencies like IC and DHS, processes shrouded in opacity. And we will confront the ultimate, sobering question. In the absence of clear criminal liability, transparent oversight, and accessible civil remedy, what does accountability even mean? Our journey begins not in Minnesota, but in the foundational bedrock of the American legal system, the concept of sovereignty itself. Part 1. The bedrock of impunity, sovereign immunity, and its iron wall. To understand the legal landscape of the Minnesota shooting, one must first confront a doctrine that feels archaic, almost alien to modern democratic ideals: sovereign immunity. At its core, it is the principle that a government cannot be sued without its consent. It is a legal inheritance from English common law, rooted in the divine right of kings, the notion that the sovereign is the source of law and thus cannot be subject to it. The young United States adopted this doctrine, not for a monarch, but for the state itself. In the 1812 case, the Schooner Exchange v. McFadden, Chief Justice John Marshall articulated this, stating the United States, as a sovereign, had full and absolute territorial jurisdiction, but also possessed the immunity that all sovereigns have retained to themselves. This is not abstract history. It is the first and most formidable barrier any victim of alleged federal misconduct faces. You cannot simply file a lawsuit against the United States for damages because an ICE officer, a federal employee, violated your rights. The government is protected by this iron wall. Congress, however, has chiseled a few highly specific gates into this wall through legislative waivers. The most significant is the Federal Tort Claims Act, FTCA, of 1946. The FTCA provides a limited waiver of sovereign immunity, allowing individuals to sue the United States for money damages for injury or loss of property, or personal injury or death caused by the negligent or wrongful act or omission of a federal employee acting within the scope of their employment. This sounds like the answer, but the FTCA is a maze of exceptions and conditions. Crucially, the FTCA is a tort statute. It deals with negligence, with careless driving, with medical malpractice in a federal prison. It is poorly suited and often entirely inapplicable to intentional constitutional violations like an alleged unjustified shooting. Furthermore, the FTCA explicitly retains immunity for a host of intentional torts committed by law enforcement officers. Known as the law enforcement proviso, it waives immunity for certain acts like assault, battery, false imprisonment, and malicious prosecution. But this proviso is itself subject to a critical limitation. It only applies to acts committed by officers engaged in investigative or law enforcement activities. And here, the first thread of our specific dilemma appears. The courts have grappled with whether immigration enforcement, a civil administrative function, constitutes law enforcement activities in the same sense as criminal policing. The line is notoriously fuzzy. More devastatingly, the FTCA incorporates the discretionary function exception. This preserves immunity for any claim based on the performance or failure to perform a discretionary function or duty by a federal agency or employee, whether or not the discretion involved is abused. An officer's decision to use deadly force, a split-second judgment call, is almost invariably argued by the government to be a protected discretionary function. Winning an FTCA case against a federal officer for a shooting requires not just proving the act was wrongful, but vaulting over these procedural and doctrinal hurdles, a task that has defeated most plaintiffs. So, if suing the government itself is a labyrinth with a likely dead end, what about suing the officer personally? This leads us to the next, equally fraught avenue, the Bivens action. Part 2, the shrinking door, Bivens actions, and the shadow of qualified immunity. In 1971, in Bivens versus 6 unknown named agents of Federal Bureau of Narcotics, the Supreme Court performed a kind of judicial alchemy. The case involved a warrantless search and arrest. Since no statute allowed a direct suit for a Fourth Amendment violation by federal agents, the court implied a cause of action directly under the Constitution itself. This was a powerful tool, a recognition that the Constitution's guarantees must have a remedy. For a time, Bivens was extended to other amendments, a Fifth Amendment due process claim, Davis versus Passman, and an Eighth Amendment cruel and unusual punishment claim, Carlson versus Breed. But since the 1980s, the Supreme Court has consistently refused to extend Bivens to any new context and has actively narrowed its application. The court now views the Bivens remedy as a disfavored judicial activity. In recent decisions, like Ziegler versus Abbasi, 2017, and Hernandez versus Mesa, 2020, the court has erected a daunting two-step test. First, is the case meaningfully different from the 3 existing Bivens contexts: Fourth Amendment search, Fifth Amendment gender discrimination, Eighth Amendment prison medical care? Any new context triggers extreme judicial caution. Second, even if the context is not radically new, the court must ask whether there are special factors counseling hesitation in creating a judicial remedy. What are these special factors? They are a catch-all for judicial reticence. The presence of alternative remedial structures, even ineffective ones, the potential impact on national security, the separation of powers concerns about judiciary interfering with the executive branch's conduct of foreign affairs or immigration enforcement. In Hernandez, a cross-border shooting by a Border Patrol agent, the court found that national security and foreign relations were special factors that barred a Bivens claim. The reasoning is chillingly applicable to our IC shooting. Immigration enforcement is a complex, politically charged arena with profound implications for national sovereignty. The court is deeply reluctant to step in. And then, towering over even a successful Bivens argument, is the doctrine of qualified immunity. This is not a federal-specific doctrine. It applies to state and local officials as well under 42 U.S.C. Section 1983. But for federal officers in a Bivens suit, it is an equally potent shield. Qualified immunity protects government officials from personal liability for constitutional violations unless the official violated clearly established statutory or constitutional rights of which a reasonable person would have known. This clearly established law standard is often fatal. It requires a plaintiff to point to a prior case with virtually identical facts. Not a general principle. Excessive force is forbidden, but a specific precedent. An ICE officer shooting an unarmed, non-resistant subject during a street stop in Minnesota in broadly similar circumstances. If such a case does not exist, and it often doesn't, given the infinite variety of real-world encounters, the officer is immune, even if their conduct was objectively unreasonable and violated the Constitution. The law effectively grants officers one free violation of your rights. The practical result is that cases are dismissed before a jury ever hears the facts. The legal question becomes not, did the officer do wrong, but was the officer's specific brand of wrong already cataloged in a judicial opinion? So, we have a landscape where suing the government is exceptionally difficult, and suing the officer personally is increasingly impossible. Where else can we look? Inside the agency itself. Part 3. The black box, internal accountability, and the illusion of oversight. When external legal remedies falter, the public is often directed to trust internal mechanisms. The matter will be reviewed internally, the statement reads. For ICE, this primarily means investigations by the Office of Professional Responsibility, OPR, within the Department of Homeland Security, DHS. Additionally, DHS has an Office of Inspector General, OIG. These processes are, by design and necessity, opaque. They are administrative, not criminal. Their purpose is not to establish guilt beyond a reasonable doubt for public prosecution, but to determine if departmental policies were violated and what, if any, disciplinary action is appropriate. The standards of proof are lower, the rules of evidence are internal, and the findings are rarely made public in their entirety. The limitations are profound. First, investigative independence is always in question. OPR investigators are employees of DHS, the same department that houses ICE. While they strive for objectivity, the institutional pressure, both explicit and implicit, to protect the agency's reputation and its personnel is immense. The thin blue line ethos exists in federal law enforcement. Second, the disciplinary outcomes are hidden. An officer might be found to have violated policy and receive a suspension, a transfer, or even dismissal. But these records are generally protected as personnel matters. The public and the victim's family may never know the result. This secrecy destroys public accountability and fosters a perception, whether accurate or not, of a cover-up. Third, and critically, internal reviews do not provide a remedy to the victim. A finding of misconduct does not result in compensation for medical bills, lost income, or pain and suffering. It is a closed-loop system of professional accountability that leaves the harmed individual legally and financially adrift. Furthermore, the policies governing use of force by ICE are themselves a subject of debate and periodic revision. They are not identical to the standards applied to local police under the Fourth Amendment's objective reasonableness test from Graham versus Conner. ICE policies may incorporate considerations unique to the civil immigration enforcement context, potentially creating a more permissive standard for the use of force than would be acceptable for a local sheriff's deputy arresting someone for a crime. This creates a legal twilight zone where an officer's actions might be sanctioned internally as within policy, yet appear to the public as a grotesque abuse. This brings us to the heart of the jurisdictional maze. Part 4. The Twilight Zone, Jurisdictional Tangles, and the Power of the Sword. The Minnesota ICE shooting did not occur in a federal enclave. It happened on a city street, under the nominal sovereign authority of the state of Minnesota. This creates a layered legal reality. On one level, the state retains its general police power and criminal jurisdiction. A county prosecutor could, in theory, bring state criminal charges against the ICE officers for murder, manslaughter, assault. But will they? The practical and political obstacles are staggering. There's a long-standing, though informal, principle of federal-state comedy. State prosecutors are often reluctant to charge federal officers for acts committed in the course of their duties, fearing conflict, a lack of cooperation in future cases, and the sheer resource drain of a high-profile battle with the U.S. Department of Justice. The federal government can also seek to remove such a state prosecution to federal court under statutes like 28 U.S.C. 1442 of the Federal Officer Removal Statute. This allows a federal officer sued or prosecuted for an act under color of office to have the case heard in federal court, which is perceived as more sympathetic. If removal is granted, the federal judge may ultimately dismiss the charges on immunity grounds, or the U.S. attorney may exercise prosecutorial discretion to not pursue them. This leads to the federal criminal option. Could the U.S. Department of Justice bring civil rights charges under 18 U.S.C. 242, the criminal counterpart to 1983? Yes, theoretically. But the burden of proof is beyond a reasonable doubt and requires proving the officer acted willfully to deprive a right. This is an exceptionally high bar, and the DOJ historically prosecutes only the most egregious, incontrovertible cases. The decision is intensely political and subject to the priorities of the administration in power. Thus, the officer operates in a twilight zone. They are a federal agent, enforcing federal law, shielded by federal immunity doctrines, yet acting physically within a state's territory. They are simultaneously everywhere and nowhere in the jurisdictional matrix. This diffusion of authority can create a vacuum of accountability, where each sovereign state and federal defers to the other, leaving the victim in a void between them. Here lies the article's pivotal, suspense-driven question, one that goes to the core of this legal conundrum. Given that internal reviews lack public transparency, civil suits are blocked by immunity, and criminal charges are rarely pursued, what specific, actionable mechanism would you design to ensure genuine accountability for use of force incidents involving federal immigration officers? Pause and consider the immense legal and political architecture that must be navigated. Share your thoughts in the comments below. Part 5. Beyond the instant case, systemic implications and the erosion of trust. The implications of this accountability void extend far beyond one tragic incident in Minnesota. It creates a systemic peril. First, it erodes public trust, particularly in immigrant communities. The perception that enforcement officers operate with impunity breeds fear, stifles cooperation with any law enforcement, and delegitimizes the legal system entire. Community policing models, which rely on trust and voluntary compliance, become impossible. Second, it creates a dangerous precedent for the expansion of executive power. When a branch of the executive can deploy armed agents whose use of force is effectively insulated from judicial review, it upsets the constitutional balance of powers. The judiciary's role as a check on executive action is neutered. Third, it undermines the rule of law itself. The principle that no one is above the law is sacrosanct to a democratic society. When that principle appears hollowed out for a specific class of government actors, it corrodes the social contract. It signals that rights are not inherent, but contingent on who is wielding power. Potential reforms are debated in academic and policy circles, but face steep climbs. Legislative repeal or reform of qualified immunity. A clear congressional statute creating a cause of action for violations by federal officers, replacing the judge-made Bivens doctrine, mandating public release of internal disciplinary findings in use of force cases. Establishing fully independent civilian review boards with subpoena power for DHS, or clarifying in statute that immigration enforcement is a law enforcement activity fully subject to the same constitutional restraints as criminal policing. Each of these solutions encounters fierce political opposition, institutional inertia, and complex legal trade-offs. The status quo, for all its moral failures, is legally stable and politically convenient for those in power. Conclusion: the unanswered echo. The echo of the gunshots in Minnesota fades. The news cycle moves on. The internal report is filed away, its conclusions sealed. The civil suit is dismissed on immunity grounds. The county prosecutor issues a statement about the challenges of charging federal officers. Life continues. But in that silence, the legal issue nobody is talking about screams. We have constructed a system where the most profound exercises of state power, the taking of life, liberty, and bodily integrity, can occur in a space of radical legal ambiguity. We have layered doctrine upon doctrine, sovereign immunity, Bivens retrenchment, qualified immunity, jurisdictional comity, internal opacity, until we have built a fortress around the actor, leaving the victim outside the walls without a key, without a map, and often without a voice. This is not an argument against immigration enforcement. It is an argument for the legal accountability that must attach to all state power in a republic. The Minnesota shooting is not an anomaly. It is a symptom. It reveals a void not in our compassion, but in our constitutional architecture. Until we muster the political will and legal creativity to fill that void, to subject every officer of every agency to the clear and present force of law, we are all complicit in the silence. The bullet finds its target, but the accountability forever is lost in the void. If you found this deep dive into the hidden legal architectures that shape our world compelling, please subscribe to the channel. We are committed to unpacking the complex, often overlooked issues at the intersection of law, power, and justice. Your engagement helps bring these critical discussions to light. Hit the subscribe button and turn on notifications so you don't miss our next investigation.